Welcome back to the Future of Europe. Joining us as first guests, two LLM students in international and European law, Samia and Céline.
Hello.
They both conducted intensive research to understand the legal issues of two important cases rendered by the Court of Justice of the European Union in 2022. First, we have Samia, who worked on the case Commission v France rendered in the 28th of April 2022. Welcome, Samia.
Hello, thank you for having me.
And joining us, we have Céline, who worked on the case Ministre de la Transition écologique and Premier Ministre, rendered by the Grand Chamber of the Court the 22nd of December 2022.
Pleasure to be here.
So before going to further details in air pollution, in your opinion, how crucial is the right to live in a balanced environment, considering the challenges we face today?
I would say that the climate issue is even more crucial today than it was a few years ago because of the constant degradation of ambient air quality and the environment in general. The right to live in a balanced environment is incredibly crucial, especially given the challenges we face today. Our environment sustains all life on Earth, providing us with clean air, water, and food, and this is essential for human health and well-being. However, we are currently facing significant environmental challenges such as climate change, habitat destruction, and pollution, which threaten the balance of ecosystem and jeopardize our quality of life. And last but not least, it's important to mention that 2023 has been the warmest year ever recorded in the world, which underscores the urgency of addressing climate change and its impact on the planet.
Yes, I agree with Céline. This is why in France, the right to live in a balanced environment that respects everyone's health has acquired constitutional value by appearing in the Environment Charter. And also the right granted to everyone that they can breathe air that does not harm their health is also codified in the Environmental Code in France. In practice, now public policy are dictated by the EU through various directives, and those directives, especially Directive 2008-15, set limits of pollution levels, and member states have to take concrete measures to respect those levels.
Okay. Therefore, can you provide an overview of the European Commission's stance on air pollution and the significance of the cases you worked on?
The European Commission has taken significant steps to address air pollution through legislation and monitoring directives aimed at protecting citizens from its harmful effects. But despite some improvements noted in assessments such as reduced incidences of pollutant between 2008 and 2017, the challenge of air pollution remains unresolved, and this persistence is particularly evident at the member state level, where many countries, including France, continue to exceed air quality limits. So legal proceedings have been initiated against non-compliant states, emphasizing the importance of compliance with environmental standards. Moving forwards, continued efforts are necessary to fully meet quality objectives and safeguard human health and the environment across Europe. I don't know if that aligns with your perspective as well.
Yes, totally. The European Commission has been actively engaged in addressing the pervasive issue that is air pollution, recognizing its severe implication in public health, but also for the environment. The Commission versus France case is a notable legal action taken by the Commission against the French government. The case was about allegation against France that they failed to enforce the public policies, and they did not meet quality standards established by the EU. So it appears in both Martinique and in the city of Paris, putting in risk the health of the citizens. So the significance of this case lies in its potential to support precedent case, and to show how the EU member states are held accountable for environmental responsibilities. It also underscores the European Commission commitment to ensuring that member states adhere to established standards, and they want to promote a collective effort to combat air pollution for the benefits of European citizens. However, various member states such as Bulgaria and Greece has already been condemned for this infringement, but they did not really encourage other member states to take concrete measures to comply with the directive.
Okay, and was it the same in your case, Céline?
Basically, the case I worked on differs markedly from hers because in this instance, it's not the European Commission, but an affected individual directly harmed by the France's violation of the directive who seeks the France's liability and who seeks a compensation. And this highlights the pressing need for a healthy environment that is now tangibly felt by the individuals, and it signifies a shift from abstract and theoretical to concrete evidence concerning the risks of climate change.
Okay, so if I understand correctly, each of your cases raises the possibility of holding the state accountable.
Yes.
Okay, so how does those cases exemplify the concept of state liability in the context of air pollution within the European Union?
Well, my case was engaged by the European Commission, and it served as a compelling example of the concept of state liability in the context of air pollution within the European Union. It underscored the principle that member states can be liable if they did not comply with the European standards. In this particular case, the European Commission contended that France breached its obligation under EU law by not implementing sufficient measures to reduce air pollution in 2 areas of the countries. And here the concept of state liabilities implies that states are accountable for their action, but also their inaction in the context of environmental law. I think it's also helped the EU to take serious action against member states. And we show that the EU is really promoting air environment and environmental law in general. I don't know if Céline will follow me in this, but I think she will explain to you much more better that it's much more complicated, for citizens to engage state liabilities.
Yes, I find it very interesting to present this alongside Samia because my case deals with exactly the same subject, namely the France's violation of the European directive regarding air quality. But the final outcome is completely different. And we can notice that this difference lies solely in the nature of the claimant. When it's the European Commission itself, France is condemned. But when its individuals are directly harmed by this violation, then France's condemnation must meet many more conditions. Therefore, in my case, it was important to recall the conditions for holding the state liable by an individual, as outlined in the famous Frankovic case. So in substance, the claimant failed to meet the requirements, thereby precluding him from holding the state accountable under the provision of that directive. So this demonstrates in a certain way that the concept of state liability is subject to strict conditions, even in the significant context of air pollution.
Okay. All right, so it appears that both of your cases carry considerable significance in terms of environmental impact on environmental issues. Yeah. They could potentially shape the future of Europe in this regard. Therefore, what potential implication does the outcome of these 2 decisions hold for other European Union member states and their approach to fight against air pollution?
Well, in my opinion, the outcome of France versus Commission case could have far-reaching implications for other European member states in their approach of combating air pollution. The court ruled in favor of the European Commission, so it may encourage stricter adherence to established standards in EU. However, many environmental lawyers believe that the infringement procedure in those cases is not sufficient. They complain about 2 major issues. First, the length of the procedure, but also the lack of financial penalties for member states. Indeed, I think with concrete financial penalties, the case could have served as welcome for other member states, emphasizing their need to comply with EU and the law and the directive. And it will also reinforce the idea that states can be held legally responsible and they can even be sanctioned for inactions for the protection of environment.
Yeah, I completely agree with Samia on this point. Financial penalty would be more appropriate, especially given the specific context of environmental issues and member states' obligation in this regard. Concerning the outcome of my case, I think that it will likely discourage other individuals from bringing similar cases before the CJEU. Indeed, since there have been no sanction imposed on France for its breaches, even though they directly affected individuals' health. Then why embark on such a lengthy procedure if the right to a healthy environment is not genuinely ensured? And how can it be ensured without the implementation of deterrent sanctions? So these are questions I was asking to myself after working on this case, and that I'm still asking to myself.
Okay. Well, I hope you will find answers soon on these issues. As we conclude our discussion on the future of Europe, it's evident that proactive measures and intervention from the Court of Justice of the European Union will be imperative while we are facing more and more environmental challenges. Thank you to our guests for their insightful perspectives.
Thank you.
And thank you to our viewers for joining us in this crucial conversation.